Hello everyone, I'm Professor Paul Carrier of the Western Michigan University Thomas M. Cooley Law School, and I'd like to provide some background information that is relevant to Class 10 of our sales class. We are now in our third week of covering concepts from Article 2 of the Uniform Commercial Code. Please never forget that when you are on a bar exam or in the real world, you will be looking at your state's adoption of the Uniform Commercial Code, which, for example, in Florida is nearly exact. There are very few differences. Other states have different tweaks, different changes, different ways of doing at least certain topics you need to be very careful to know about if you are, in fact, practicing in those states. So, we have a lot of concepts today. None of them are all that complicated, and with a little bit of background information and an understanding of some factual context, it should be easy to highlight these in your code book so that you can identify quickly which ones apply, what they mean, where they have exceptions, whether they have special tests or rules. It's really not that complicated. And again, it's a lot of material to read, but it's not that hard to get your minds around the concepts. Certainly easier than what we had to work with in Article 3. So anyway, today we're going to be talking about gap fillers first. And that is where, as you know, when you accept a contract or an offer, even though certain things are not exactly the same, you probably still have an offer, and we take those additional terms or different terms and determine whether they go in or they don't go in. But we still have a contractual agreement. As well, often when parties are engaging in the sale of goods, they talk about the main terms, often called the Dickert terms: price, quantity, shipping date, who insures it. But they don't talk about little things like whether it's packaged in foam or in plastic, whether it is red or green if it's a product that has just a huge market. So the color doesn't matter, you buy in so much bulk. And yet, even though those little details are not agreed, we should have a contractual arrangement, but then something goes wrong. For example, all of a sudden in the market there's a huge price drop, and then the buyer is looking for any reason to get out of the contract, for example. Oh, well, you forgot to mention if it was going to be shipped before noon on Friday or after 12 noon on Friday. That makes it so scary and so non-specific that we didn't have an agreement really. Well, come on. We know better than that. The world knows, the courts know, the other side knows, and so we have these gap fillers to kind of solidify things that are not really agreed upon, but nevertheless are usually the subject of a little bit of phone calling back and forth. Ed, I need it by Friday. Great. Is that in the contract? No. Do they do it by phone every time? Yes. And so they probably have an agreement, the proper intent, offer and acceptance, and they will work out those little details. And when they refuse to, or want to find a reason to get out of a contract when they shouldn't, we have these gap fillers. And you'll find them primarily in Article 2-305 to 2-311. There are others, but the primaries are in 2305 to 2311. They include an open price term. If there's an open price term, do you have an agreement? In many cases you do. If it's a really important Dickert term that's left open, it could indicate that you don't yet have the contractual intent on both sides. But often you do, because you're going to agree on the price. Market price plus 3%, measure the day we order it, which will be next week. Okay? It's open. Okay? But it's not so open that there's not a good basis to develop. So we just use a gap fill as opposed to say that there's no formed contract. Output and requirements contracts. One thing the UCC does not do is does not enforce contracts over the amount of quantity stated. That's one thing for which there is no gap filler. However, if you have an output contract, which is I'll buy everything you make, or I'll buy half of everything you make, as long as it's clear, or a requirements contract, I will buy everything I need from you. And if I need 100, I take 100. If I need 300, I'll buy 300. Those things are subjected to this general gap filler, this generally included term of operating in good faith. And so you pick a number of how much you would order or how much you would supply based on how much you would actually be doing if you were acting in good faith. So the argument, oh, that wasn't clear enough so I can sell it to the Chinese for triple, is probably not going to work. Okay? Delivery in one lot or several. You order 1,000 logs. Do you get 10 orders of 100? Or do you get one big day's worth of shipping so that they all come on the same day? You can always agree otherwise, but if you don't, the code presumes in one delivery, unless the facts indicate something bizarre. And that is, in fact, in 2-307. 2-308, place of delivery. There could be insurance risks. There could be significant cost of transport. There could be timing issues. And so if you leave a delivery place of delivery open, there is a default. And as I recall, it is the seller's factory. And if you don't like that, change it by contract. If you fail to do that, the law needs to pull in and fill that gap, and will pick seller's warehouse. Okay? Time for delivery, if not specified. And as you can imagine, it would be within a reasonable time under the facts and circumstances. Time for payment. Well, when you get the good, you should pay for it. Unless you agree otherwise, like 10 days after receipt, 30 days after such and such. End of the month. Fine, if you agree otherwise. If you do not agree otherwise, once you receive, you should pay. And that's the default. Again, if you don't put it in to your contractual relationship, we want to preserve the contractual relationship and find a way to hold the patch together by one of these gap fillers. 2-311 is somewhat generic. If there's an agreement that leaves certain spaces open, not too big, not the really big dicker terms, then 211 lets us know, 2311, forgive me, lets us know that just because there are a few things that are not there, there are the spirit of the UCC is to keep the relationship together and have parties honor their bargain and fill in and work out the details that have not been fully hashed out. That's the plan. So if you leave out a few small details, that should not be fatal to a contractual relationship. Also, there are other places, but generically you have the duty of good faith, duties of fair dealing, duty of acting commercially reasonably. Some of them are generic and cover everything in the code. Others are laid out or set out specifically in certain specific provisions. And so sometimes you have to look at a provision, it says, and good faith and commercially reasonable, that might be different than the Article 1 version or definition of good faith. It might even be heightened. So sometimes there are different gradations or levels of good faith based on the nature of the problem that an article in UCC Article 2 is attempting to prevent. Okay? Okay, let's talk about open price amounts. If you leave an open price amount, the other party who should set the price should set it in a commercially reasonable fashion under the facts and circumstances. The case that you have in the case book goes one step further. Is this testable? Well, it might be, particularly on a bar exam. And if you know this, you probably know everything else that underlies it about the open price term. And what that does is the UCC in 2-305, sub 2, contains a special safe harbor. It's where if the party that has the right to set the price posts a price and then applies that price without discrimination to similarly situated parties, it is given the presumption of validity, and we check that objectively. And we don't check for the reasons why they're setting the price that way. So, typically with an open price term, there could be an objective and a subjective test, but there's a safe harbor with a posted price where it's put out there based on these factors. Here it is, and it includes application to similarly situated parties in the same amount, so that there's no discrimination. Okay, so I think that taking this to an extreme is the case that we see, if I'm correct, it was Casserly. And we'll talk about that, of course, further in class. Identifying goods to a contract for risk of loss purposes. If I'm catching fish and they all die, I lose. If I caught fish, I put them in a box and I address it to you, maybe you have the risk of loss at that point. If I've identified them to your contract, the risk of loss may have shifted. I want you to understand in 2-501, who has title is no longer a guiding principle for who bears risk of loss. I may have title until you've paid me, but the risk of loss might be on you as it crosses the ocean over toward you. And so you see, you don't have title yet, but you might have risk of loss. And so those two, title and risk of loss, are divorced in the Uniform Commercial Code and given to parties based on commercial realities, not on who has title. There is a risk of loss when there is no breach. If nothing goes wrong, but the goods go kablooey for some reason, like they sink while they're crossing the ocean. No breach, though. With regard to the transaction, it's a third-party carrier where something goes wrong. There are two risk of loss rules, and one is called, well, it's two contracts. One is a shipment contract and one is a destination contract. And if it's a shipment contract, the risk will change at a particular point. And if it's a destination contract, the risk will shift from buyer to seller at a different point. And we will cover that in more significant detail during the class period. What if there is a breach? Somebody sends the wrong goods, and then there's a loss, an insurable loss. Who bears the risk then? Well, in that particular case, risk stays on the seller until the cure has been effectuated. So if there's a breach, the risk stays on seller and does not flip to the buyer unless and until it's reached the buyer, he or she's accepted it, or he or she's given the seller a time to cure. There are some terms with regard to shipping and risk of loss and insurability and who pays the insurance, free on board, free alongside, and we'll talk about those very briefly, although those are not a big part of what we're going to cover in our sales class. Okay? Installment sales. When you buy something and you want it tranches. You buy 1,000 logs, I want 110 different shipments. I don't need 1,000 at one time. The big issue there is, what if one of those shipments of several constitutes a breach? Well, that is treated ordinarily as a breach only of that shipment, which should be separately or distinctly fixed, or you sue for breach of warranty, whatever your remedy would be, you do it for that shipment, but not the entire contract. Key, however, is if that shipment is a breach, and that breach substantially damages the value of the contract, substantially impairs the value of the entire bargain, then that breach of one shipment can be treated as a breach of the entire contract, where it's a very big deal. And in class, I will try to give you an example of that. There is this concept of substantial performance in the common law. Installment sales and the breach of one installment is not the breach of the entire contract, usually is the only place in the Uniform Commercial Code that even considers the substantial performance doctrine, but by the time we get to the perfect tender rule, we do not. If the goods do not conform to the requirements of the contract, the buyer has the right to reject them all right there. And the seller has to prove it was not a nonconformity in order to overcome the buyer's right to reject the goods. Buyer can reject all, can reject some, can keep them all, and sue for breach. There are certain other ways that, for example, if you get something that's non-conforming but it's a small difference, you may still want to use it in your product and just sue for the damages. That certainly can be done. But don't forget the perfect tender rule. Mechanics in non-conformity, you can reject. A buyer can reject a non-conforming seller's shipment. That's the basic one, and usually that works to the seller's advantage. If the seller, or the buyer, forgive me, if the buyer has decided to accept it, then if it's something that's a little bit hidden, hard to find, or the buyer needs the right time to inspect, then the buyer might have accepted but still has a chance to revoke acceptance. And if there's, for example, something that's hard to find out, then you might still be able to revoke. But the problem with revocation is that the buyer now has to prove that. It's not the seller proving, it's the buyer proving that. And let's see, there's also warranty liability we'll get to later. So you've got rejection, revocation, warranty liabilities as the hierarchy of damages that a frustrated buyer can get where the seller breaches. Very quickly about lemon law. Some states have lemon laws with regard to certain products. Often, well, in fact, I'll talk about the lemon laws in class. Okay?